we, a constitutional democracy, as members of the legal profession, judges and lawyers, do we have a duty or obligation to guard the Constitution, which is the supreme law of the land? Should the third arm of government be proactive or complacent in protecting the rule of law? The society is weighed down by several prejudices, partisan politics, tribalism, statism, insecurity, corruption, to mention a few. Social values have changed. In our peculiar circumstances as a nation, what role should the bench and bar play in bringing about social cohesion, equity, justice, and respect for individual liberties enshrined in Chapter 4 of the 1999 Constitution? I hope I will be able to answer these questions and provide solutions to the myriad of problems besetting the nation. What is division of labor between the arms of government? The torchbearers of the concept of separation of powers, John Locke, posits thus, I quote, "It may be too great a temptation to human frailty apt to grasp at power, for the same person to have the power of making laws, also to have in their hand the power to execute them, whereby they may exempt themselves from the obedience to the laws they made, and suit they both in its making and execution to their private advantage." Montesquieu corroborates John Locke when he said thus, I quote, "Political liberty is to be found only when there is no abuse of power. But consistent experience shows every man invested with power is liable to abuse it and carry his authority as far as it will go. To prevent this abuse, it is necessary from the nature of things that one power should be clinged on another. When the legislative and the executive powers are united in same person or body, there can be no liberty. Again, there is no liberty if the judiciary is not separated from the legislature and the executive. There would be an end of everything if the same person or body, whether of the noble or the people, were to exercise all the powers." From the foundation laid by John Locke and Montesquieu, it is obvious that the essence of the creation of the various arms of government is to protect, safeguard, and guarantee the liberty of the people, and to serve as a wedge against the tyranny which an unregulated and unchecked power would foist on society. Thus, the theory of separation of powers is made necessary by the need to preserve the freedom and ensure that the liberty of the people and the society, which was in the first place the basis of governance, is not trampled upon. Sections 4, 5, and 6, respectively, of the 1999 Constitution defines the three arms of government in Nigeria. Furthermore, the theory of separation of powers is built on the belief that if the executive, legislative, and the judicial powers are vested in one person or group of individuals, such people will have unlimited powers in such a way that they could prescribe any law, arrest anyone, and even prosecute same for no reason. Since they exercise unlimited powers, they may pronounce even a falsely accused person guilty without a chance to defend himself. Without the intent to subject you learned colleagues, lawyers, and judges to the boredom of a lengthy lecture, it is apt to remind ourselves and reiterate the position that the supreme law of our land, the 1999 Constitution of the Federal Republic of Nigeria as amended, recognizes and reinforces the principle of separation of powers between the various arms of government. The executive power of the state is vested on the executive arm, the law-making powers on the legislature, and judicial powers on the judiciary. There is therefore no question as to the existence of separation of powers between the arms of government in Nigeria. The focus therefore is captioned under the underlisted areas which shall further guide this discourse as we progress along. What is the relationship between the three arms of government? What are the possible areas of conflict between the arms of government? And what are the resolutions of disputes? What areas can these disputes be resolved? I go to the relationship between the arms of government. The role of the three arms of government has been well spelled out in the Constitution. They are thus separate arms of the same government. Various schools of thought have emerged on the relationship between these arms. While some argue for a strict separation of powers, others toe the line of liberal separation and mutual cooperation between the arms of government. Some others have argued that there is no watertight compartmentalization of the three arms of government, suggesting a coexisting and power-sharing relationship between the arms of government. This position also aligns with the structure of many advanced democracies from where Nigeria copied its own model. Synergy between the executive and the legislature is even more crucial for facilitating good governance. The importance of the adherence to the doctrine of separation of powers by the three organs has been sounded by the Indian political scientist Arun Appadurai in his book, The Substance of Politics, that, quote, such separation is necessary for the purpose of preserving the liberty of the individual and for avoiding tyranny, end of quote. The import of the above, therefore, is that the relationship that exists or ought to exist between the three arms of government is one that is cordial and cooperative, yet firm, as to enable each arm serve as the ombudsman on one another in the overall interest of the people. Besides, it is the design of the proponents of the doctrine of separation of powers that the various arms of government depend on one another for existence and termination where the need arises. For example, the executive arm, headed by the president, though elected at a general election, must be sworn in by the judicial arm of government, headed by the Chief Justice of Nigeria. In the same vein, the legislature, that is the National Assembly, upon election by their various constituents, do not come into existence unless convoked by the President through the transmission of a letter to that effect. Similarly, heads of the judicial arm are appointed by the executive and confirmed by the legislature and sworn in by the executive in order to resume office. It is thus safe to conclude that it is near impossible for a watertight separation between the various arms of government. What is more, healthy cooperation between the various arms of government would translate to good governance and welfare of the citizenry. So what are the areas of conflict between the arms of government? As stated from the outset, intergovernmental conflicts are inevitable between the various arms of government. This in itself is normal and tolerable. However, there is the need to find a nexus between those conflicts and the core objective of governance, which is providing the greatest happiness to the greatest number of people. That is, are those conflicts as a result of advancing the interests of the people which they govern, or those conflicts are merely to further parochial, ethnic, self-interest, and interest of political affiliations. Using the Nigerian experience, the media is daily inundated with reports of conflicts between either the presidency and the National Assembly, or between the various agencies of government, and more recently, between the executive and the judiciary. Various factors have been identified for this seeming rift. I will focus on a few of them. 1. Partisan politics and godfatherism. Party politics is a hallmark of Nigerian democracy, as the Constitution abhors independent candidacy. Elected officials and political appointees, immediately after being sworn in, start the race for the next political placement, rather than attend to matters of the state with patriotism. 2. disrespect for the institutions of government and the Constitution. It would seem that the political actors in Nigeria have not developed the culture of mutual respect and cooperation. 3. Conflict of roles. Though the Constitution has provided distinct roles for the various arms of government, there are still issues surrounding the extent and boundaries of these powers, and this has generated a lot of conflict in the process. A case in point in Nigeria has to do with the issues of budgeting for the Federation and to what extent the legislature can tinker with the figures and projects as presented to it by the President, which has birthed the concept of budget padding in Nigeria. 4. Executive dominance of the other arms of government. There is a growing perception among Nigerians that the executive arm of government, by its actions, dominates and suffocates the other arms of government, and this has weakened them from checking the excesses of the executive. The allegation in the public domain is that the executive arm of government, through its security and prosecutorial agencies, has become tools of subjugation of the other arms of government. 5. Abuse of oversight powers of the legislature. The legislature in its oversight functions have equally in some cases frustrated the efforts of the executive in the task of nation building. This has also created some form of suspicion and conflict between both arms of government. The power of the legislature to confirm appointees of the government is another area of recent conflict. The National Assembly refused to confirm nominees of the President for various offices until recently. As the adage goes, when two elephants fight, the grass suffers. The Nigerian state was a grass in that power struggle. How then can this conflict be resolved? Let us at this point beam the searchlight on our constituency, the bench and the bar, and how we are fared in the task of resolving the various conflicts that are thrown up by the other arms of government. Lord Denning, in the case of Rondell and Worsley, held that the bar and the bench constitute the legal profession and they must work together in harmony and mutual respect in an atmosphere devoid of suspicion or apprehension, with the enviable aim of uplifting our judicial system, which is the only consistent and dynamic agency for the enthronement of the rule of law in our society. Nigerian legal system must be able to deliver social justice, equity, and development to the people if properly organized and motivated. It will serve as a powerful and legitimate instrument for transforming the country's decadent social-political system into a progressive and transparent one. The legal system can be of tremendous help in altering the corrosive pattern of behavior in public life which has scuttled Nigeria's development. For members of the bar, as elections draw near, pre- and post-election litigation will take the front burner. As patriots, due process, adherence to the rule of law should preoccupy your minds much more than pecuniary gains.